Good morning, everybody. We will start slowly our last day, and it's a great pleasure to have you all here today with us to discuss the procedural principles and procedural obligations towards a new approach to dispute resolution with Professor Alan Uzelach, one of the leading scholars in this field. It will be our pleasure to have today this last lecture with Professor Uzelach in this important topic for our civil procedure. I will address some words in Portuguese now, just to explain you the whole idea of the seminar, and after that we will pass the floor to Professor Uzelach. Bom, é um prazer ter vocês todos aqui hoje novamente, uma alegria. Acredito que nós tenhamos tido até agora uma oportunidade única de discutir aqui com os nossos queridos convidados, professores estrangeiros, Sandra Kramer, Henko Van Rie e Alan Uzelach, as matérias que diziam respeito, no primeiro momento, ao que está acontecendo na União Europeia e no direito europeu em termos de uniformização do direito, de harmonização do direito, de coordenação dos diversos ordenamentos jurídicos, como o projeto L-UNIDROIT se desenvolveu. Num segundo momento, nós fizemos, ao invés de uma perspectiva somente comparada do ponto de vista horizontal, uma perspectiva comparada do ponto de vista vertical, em profundidade, com o professor Henko Van Rie, e conseguimos, então, compreender que essas ideias na Europa estão circulando porque existe um passado comum, existe uma formação ideológica do direito processual que fica por trás de todos esses institutos que estão sendo discutidos agora. Avançamos nos séculos até chegarmos ao momento atual, quando o professor Henko Van Rie fez questão de fazer uma comparação entre o direito contemporâneo alemão, que foi influenciado por Franz Klein e pelas ideias contemporâneas de direito processual, e o direito contemporâneo francês, e com isso se pôde chegar às ideias mais avançadas do direito holandês e também dos projetos do ALI-UNIDROIT e das ideias que estão sendo desenvolvidas pelo Conselho da Europa. Então nós conseguimos fazer aí duas perspectivas muito amplas sobre quais são as mudanças que estão acontecendo nesses ordenamentos, e nós percebemos, se nós pararmos atentamente para observar essas mudanças, nós percebemos que essas mudanças estão diretamente conectadas com o nosso novo Código de Processo Civil. O nosso novo Código de Processo Civil, ele está preparado, se for interpretado corretamente, se for interpretado a partir dessa percepção de que existe um passado comum que nos trouxe até aqui, ele pode ser interpretado como um código contemporâneo, um código que discute as questões mais importantes para que nós tenhamos um ordenamento processual que seja mais rápido, mais barato e mais eficiente. Então, nós hoje vamos aprofundar essa discussão com um tópico específico diz respeito às obrigações das partes, dos juízes e dos advogados. O professor Alan vai descer em profundidade nessa questão para primeiro nos lembrar de algo muito importante. É muito importante que nós tenhamos aqui juízes, nós temos aqui membros do Ministério Público, nós temos advogados e acadêmicos. Lembrarmos que não são as partes que atuam no processo. As partes estão sempre representadas pelos advogados. Então, o maior problema que nós temos é exatamente a mudança cultural na atuação dos advogados e dos juízes. E o professor Alan vai aprofundar essa visão a partir do princípio ou do dever geral de cooperação. Um dever geral de cooperação que é estruturado em 4 pilares que especificam esse dever geral de cooperação. O primeiro pilar, que nós já começamos a falar nas aulas anteriores, é o case management. Então, a ideia do gerenciamento dos casos, que é tanto o gerenciamento dos casos por acordo das partes, quanto o gerenciamento do caso pelo juiz, e também o gerenciamento das partes por acordo entre partes e juízes, como ocorre na calendarização processual e como ocorre no saneamento compartilhado do processo. Depois, o professor Alan vai falar também sobre o dever específico de identificação dos fatos relevantes para a causa, de determinação de quais são os fatos relevantes para a solução do conflito e também, então, de determinação de quais provas serão produzidas para solucionar aquele conflito. Depois, também especificando o dever de cooperação leal, o professor Alan vai falar do dever de determinação do direito e de como isso é importante para que nós possamos bem solucionar o conflito. E aí eu chamo a atenção que nós voltamos a discutir o que o professor Renko ontem nos lembrou, os princípios da li factum dabitivius e iura novit curia. E essa nova relação, que não é mais uma relação de divisão de trabalho, às partes cabem os fatos, ao juiz cabe o direito, mas uma relação de trabalho compartilhado, onde fatos e direito são responsabilidade de todos aqueles que atuam no processo. E aí o quarto pilar, o quarto subprincípio, a quarta especificação desse dever geral de cooperação, que o professor Alan vai expor hoje, tem uma relação direta com tudo isso que foi dito até agora. Se nós temos um correto gerenciamento do caso, com a dimensão proporcional de esforços, de tempo, recursos financeiros, para atingir um processo efetivo, se nós temos a identificação dos fatos e as provas produzidas no processo, se nós temos a identificação do direito que deve ser aplicado, não cabe só ao juiz decidir. Cabem às partes um permanente estímulo para a autocomposição. Então, o quarto pilar que especifica o dever geral de cooperação é o pilar do estímulo à autocomposição, que é constante e é uma característica muito contemporânea do direito processual. Vocês podem ver nessa panorâmica o quanto isso está diretamente conectado com o que nós temos no nosso novo Código de Processo Civil e o quanto é importante nós observarmos a experiência europeia para não retroceder no tempo a paradigmas anteriores. Então, vou agora convidá-los a prosseguir nessa nossa jornada, nossa Summer School, não sem antes agradecer todos os apoiadores, agradecer à Universidade Federal do Espírito Santo, nossa UFES, ao PPGD, o nosso Programa de Pós-Graduação em Direito, por ter permitido que nós realizássemos esse evento, agradecer à Ordem dos Advogados do Brasil, na Seccional Espírito Santo, à ESA, a Escola Superior de Advocacia, especialmente em nome dos colegas Vinícius Pinheiro Santana e da colega Andressa, que esteve conosco ontem. Agradecer a SMAGES, que é a Associação dos Juízes, que prontamente se colocou à disposição de apoiar esse evento, e agradecer com isso a presença de todos os juízes que estão aqui hoje, participando ativamente desse evento, e em especial me referir aqui ao Dr. Jane. Muito obrigado pela sua presença, e agradecer também à doutora Janete, que permitiu que isso fosse viabilizado, junto com a doutora Mariane Judice, que foi prontamente uma defensora desse projeto. Queria também agradecer à Escola Superior do Ministério Público, da Associação do Espírito Santo, do Ministério Público do Espírito Santo, a AENS, que é hoje capitaneada pelo professor daqui dessa casa, professor Dr. Pedro Ivo de Souza, que é hoje o presidente da nossa associação, por ter também nos apoiado junto com as SMAGES na realização desse evento. Tá? E com isso, dizer a vocês que nós vamos agora começar com a palestra do professor Alan Zelati, que vai fazer uma breve recapitulação de tudo que foi discutido até aqui e depois entrar no dever geral de cooperação. My dear colleague, one of the leading scholars in this topic, Professor Alan Zelati, you have the floor.
Dear Hermes, dear friends, I'm extremely pleased to be here for the second time in the period of last 2 years. I was at this university 2 years ago, and well, to quote from a classic, this was the beginning of a beautiful friendship, and I'm now in particular honored to be here to contribute to the closing of the, as I understand, first international PROSNET meeting and colloquium, and this is indeed going to be a last presentation which follows after 2 remarkable presentations. And I have to admit, this puts me in a rather awkward position. I now need to say something new about the topics that you have been hearing about for the past 2 days. Anyway, well, I thought whether or not to follow my original outline, but since the presentation has been distributed to you, and I hope that you have the slides, I still decided to follow them. And yeah, well, like we all adore Latin sayings, I can only say repetitio est mater studiorum. This is something that my colleagues usually tell to students when they fail the exams, and it's not always a consolation. But I'm still going to try to follow more or less the presentation that I was supposed to deliver. However, I will quickly summarize some things. The presentation has been just a little slightly amended, and the titles have been removed, so you can still follow the original outline. Now, let us start. Well, in the modern time, we don't have any more papers, so I'm going to use this as my helping material. And let me first announce then the brief overview of what I'm going to tell about. Well, my presentation was originally divided in 3 parts. I wanted to say a few words about the idea of harmonization, in particular the idea of harmonization in Europe, and then proceed with the story about procedural principles. And in particular, I wanted to outline in what respect has the project of Eli and UNIDROIT, or at least a part of the project in which Professor Van Rey and myself participated, tried to distinguish itself from the previous procedural traditions. And this will then be the last part of my presentation, where I will present the main ideas in the working group, which was called Obligation of Parties, Lawyers, and Judges. And although that was only one of the 10 working groups, it had, just like Sandra Kramer in the beginning noted, it had a little bit different position. We were a kind of ideological group, and this is also probably the reason why the text of the rules which we proposed suffered from most of the amendments in comparison to the other groups. Anyway, let me start with some initial thoughts first. Let me start with my presentation of the driving forces of European harmonization. And well, what I wanted to show you are the lighthouses. There is a lighthouse here in Vitoria, a very nice one. This is yet another lighthouse. And interestingly, well, we haven't consulted a lot when we were preparing our presentations, but our lighthouses are generally the same. Although, well, everybody has personal favorites, so I'm also going to underline some of my personal favorites. Indeed, Article 6, right to a fair trial, has been mentioned, but I think we need to keep repeating that this is the basis, and this was the strongest force behind European harmonization. Right to a fair trial in Article 6, and this is now in Article 47 of the EU Charter of Fundamental Freedoms, is, I would say, the right that comprises a whole set of procedural human rights. And since we were privileged probably unlike Latin America, or maybe still there are similarities, but we were privileged to have one body, and this is the Court of Human Rights, the European Court of Human Rights in Strasbourg, which was interpreting this Article 6 in the period of over 50 years. Interestingly also, from the early lighthouses, Professor Van Rij also highlighted the Council of Europe recommendations from 1984. And I must say, this is a kind of surprise, because the 1984 recommendations on civil procedure of the Council of Europe were a kind of hidden gem. Very few people were referring to them. And now, when I keep returning to the recommendations, I realize all of a sudden that in many aspects they are better than many things that followed afterwards. Probably even better and more clear than some of the things that we have produced now for the latest project. But then, additionally, what I would like to also point to is that harmonization in Europe is, at least since the 2000s, driven by the awareness that procedural rules are just the tip of the iceberg. What is important is how these rules live in practice. And obviously, they live in practice rather differently. This was, by the way, also one of the reasons why the Council of Europe, the organization of practically all European countries, not only European Union, has established a body called the CEPEJ. CEPEJ is the French abbreviation for the European Commission on the Efficiency of Justice. And the main mandate of the CEPEJ was to see how civil justice systems, also criminal, but civil was always in the first place, how civil justice systems function in Europe, just to enable the countries to compare how their civil justice systems perform. So this idea of performance is very important, and I was privileged to be one of those who were sitting in the drafting committee that drafted the resolution that has established the CEPEJ, and I also worked for many years in the CEPEJ as a national delegate, also as a member of the bureau of the CEPEJ. It was a very interesting process, and I think still, if you seek for information, and also seek information about how really different are European civil justice systems, then you should go straight to the CEPEJ collections of facts and figures about European civil justice systems. And in fact, these figures are now being used by the European Union as well, since, well, from 2015, European Union publishes annually the EU Justice Scoreboard. You know what the scoreboard is? Well, for the country of football lovers, so you of course know that scoreboard shows what is the score in the play, and the scoreboard in a way shows how judicial systems in Europe operate. And this altogether shows that things are changing in Europe. And I will also outline that by quoting a text that was published in a book, and well, this book has been edited by Professor Van Rij and myself in 2003, Enforceability. That book was subsequently translated into Russian and some other languages. And well, one of the papers from that book was a paper of Professor Miriam Freudenthal entitled The Future of European Civil Procedure. And she started by saying that, as a rule, the law of civil procedure was and still is considered to be closely connected to the form and the forum state with its own cultural and traditional specific aspects, and therefore not fit for harmonization. And we can get reminded of Professor Cabral, days ago when he also asked, well, isn't this a matter of culture? Should we harmonize or not? Well, this is a traditional view. However, today, even in the European Union, this view is not valid anymore. Why? Well, the European Union has its law, and it needs to be implemented. But in order to implement it in a way that produces comparable results, you need a procedure that would lead to comparable outcomes. Indeed, problems arise in this process. We can ask about the power of the European Union, and obviously the mandate of the Union is so far very limited. I would personally say much too limited than it should have been. But still, this is a necessity. How to harmonize them? Soft methods have proved to be very, very important. And well, I will quote here yet another document that was already pointed to you, also by Professor Sandra Kramer. And this is a document which shows that also the European leading political bodies started to think about the necessity of procedural harmonization that would be a consistent one. Of course, I agree with Sandra that this project is limited. It's also incomplete. Results are less than spectacular. But the very fact that it exists is a significant fact. And, well, maybe we should just see some of the starting points and elements. The aim of this project, and I quote here from the working document, was to serve as a basis for convergence of national regulations concerning civil procedure, establishing a balance between the fundamental rights of litigants in the interest of full mutual trust between the judicial systems of the member states. What was then sought? It was, first of all, the result of the awareness that if Europe really needs to be unified, there should be a level playing field for businesses, and as stated in some of the elements of the preamble, establishing a level playing field for businesses can only be due to effective and efficient legal judicial systems, which at the same time facilitate access to justice for the citizens. And also the preamble emphasizes the fact that civil procedure is being already harmonized through European law, but in a rather imperfect manner, in a sectorial manner. And finally, and this can be taken as a point of self-criticism, the preamble also points to the fact and admits that the piecemeal nature of procedural harmonization in the European Union does not create coherent procedural law. So this was the reason why minimum standards were proposed. And of course, the Union always needed to find appropriate legal basis. Again, to repeat, was found in the Article 81 of the Treaty on the Foundation of the European Union. And admittedly, this is a vague provision that is also at the same time narrow in its scope. But what we see here is yet another attempt to interpret it broadly. And I think that, well, we may wait for some time until this will become a prevailing opinion, but ultimately I'm convinced this is something that must happen if the European Union wishes to survive. Most interestingly, the European Project on Common Minimum Standards already mentions the influence of academic work in this area, especially the model project. So, in particular, it mentions the influence of both the American Law Institute and UNIDROIT transnational principles, but at the same time, it also mentions the European Law Institute and the UNIDROIT project from transnational principles to European rules of civil procedure. By the way, let me ask you, when is this document drafted? 2017. What is the status of the Eli Unigra project? Well, you can see that we are still not there. We will have to wait most likely until May this year to have this document finally adopted. But even though it is an incomplete project, an unfinished one, it has already been mentioned by the, let's say, well, probably the European Parliament is not the most important political body in Europe, but certainly a body that becomes more and more prominent, and it is the democratically elected body of European citizens. Now, also one interesting thing about the common minimum standards of civil procedure in the European Union. They contain some rules. And again, I agree with Sandra. These rules are kind of eclectic, operate at general level, probably could have been better, could have been more broadly discussed. However, what we can see in these rules is the strong emphasis on effectiveness and efficiency. And we can see it first in the starting provision on general obligation of effective judicial protection, very importantly. And it's a new philosophy. We start with this as the first principle. And then what we also have is the provision of Article 7 on procedural efficiency. Above all, what we see here is the Rule 21 on obligations of the parties and their representatives. And, well, this rule has obviously been under the influence of the, guess what, obligations group that Remco and I chaired within the ELI and UNITRA project. So obligations are important. Now, where is this emphasis on efficiency and effectiveness coming from? I have already mentioned that the CEPEJ annually checks the situation in the civil justice systems, and I also mentioned the interest in real functioning of the justice systems in Europe. What we can see here, very plastically, is that judicial systems in Europe obviously function in quite different ways. Again, let me get back to Antonio Cabral and the story about procedural culture, which may be connected to the idea of procedural pluralism. And indeed, well, pluralism is a good thing. We all agree about that. However, there should be some starting points. And probably the first one is we need to trust our judiciaries from our own cultural perspective. We all live in a particular environment, so probably we can work in a different way, but we should all have the same trust in judicial systems. By the way, Europe roots in the idea of mutual trust and on the idea that every European citizen has to be equally protected wherever he or she travels in Europe, meaning that judicial systems need to provide in a comparable way. But how much do European citizens trust their own judicial systems? The empirical information, and this is the information published in the EU Justice Scoreboard. Its origins are, however, in Eurobarometer. I know that Latin America also has its barometer, statistical measurement. And what we see here are the replies on the question. There was a survey conducted in 2019. The question was, from what you know, how would you rate the justice system in your country in terms of the independence of courts and justice? Would you say it is very good, fairly bad, or very bad? And although the question is limited to independence of justice, indeed, citizens don't know how independent courts are. But know that courts must be independent, and these answers reflect their trust in the courts and not the real situation with the judicial independence. So what do we see here? What we see here is that situation is really immensely different. What we can see here is, inter alia, that we have about half of the countries, or over half of the countries of the European Union, in which population does not trust the independence of judiciary. Of course, we have some countries where judiciary is rather trusted, and well, high trust is something that we can find in Scandinavia and some other countries. Well, starting with Denmark, Finland, and then we have Austria, Sweden, Ireland, and only then we have Germany, and even worse than Germany is the Netherlands, but still good. And then we have United Kingdom, and France is probably just the, let's say, barely over 50% of trust in this comparison. Low trust, on the other side, is something that we can find in transition countries, and unfortunately, the lowest trust here is my own country, Croatia. But we have here also Slovakia, Bulgaria, and then a number of southern European states like Spain, Italy, Romania, Portugal, and also, well, Malta and Greece. All countries in which, as we can see, the blues, which mean we think situation is very good or fairly good, are much behind the reds, which mean not good. And I will just show you briefly how it goes for details. For instance, from the direct comparison of Denmark, which was #1, and my own country, which was on the opposite side. It shows that, for instance, in my country, only 18% of population trusts the independence of judiciary. However, we can also see that this is 18% that think it's fairly good. Nobody thinks it's very good. And, well, 45% plus 30%, totally 75% distrust. 3/4 of population distrust the courts, distrust the justice system. In Denmark, on the other hand side, what we have is also some people who are not satisfied. But how many? 1% think situation is very bad. 1% thinks situation is fairly bad. And then we have 94% of people who trust the judiciary. And we also have among them over 50% that think that situation is indeed very good. So what can we conclude out of it? I think that there are a number of conclusions that we can draw, and I will here actually give some conclusions not only about this, but also about my previous submissions. These conclusions are only interim because we will go later to the topic of the European rules of civil procedure. And still, these conclusions are that Europe is developing, and although we have some Brexit-like centrifugal forces and still a lot of doubt about the future of the European project, on the other side, harmonizing forces continue to shape the reforms, and they continue to shape the reforms of the national procedural laws in Europe. So what we can see is a process which will go in the future into a stage of more universal systemic study of procedure and also reforms of the procedure. So far, reforms were very fragmented, very segmented, sectorial, so to say. Model rules of civil procedure probably have the best chance to be the tool of such harmonization process. and they have the capacity to play a decisive role in the discussion of new codes and amendments of civil procedural legislation. But we have to ask, where are they going to be used the most? They are going to be used the most in that other half, in the red rectangle from the previous slide, and this means in the countries which experience the crisis of public confidence in the justice system. So I think what we see as rather likely is that they will play a big role in countries like Serbia or, well, Italy. And right now, after Brazil, I'm traveling to Armenia, and I'm going to talk about the model rules of civil procedure, because this is the country which has enacted a completely novel code of civil procedure. They have literally discovered case management as for the first time. These rules will probably not play so much in countries like the Netherlands or England. They will more likely be there as another proof that their systems are good. So I'm very pleased by the fact that I'm speaking about European rules in Southern America, because maybe these rules are going to have more impact in Brazil than in Belgium. However, they are important. In any case, for the countries that will wish to become a part of this new European system, and there are still a number of candidate countries from, so to say, Balkan region to Caucasus region, it seems that the study of ELI UNITROC project and of the EU minimum standards will become a mandatory reading, a mandatory starting point. And, well, what we need not emphasize, that was very plastically shown on the last slide, we have to keep in mind that legislation is important, but even more important is the proper functioning of the civil justice system in general. And this is something that now can be almost measured, and we have this measurement which is also dynamic. It changes from year to year. So, with your permission, I would conclude my first part out of 3, and I will now go to the machine. This is still working well. It seems that can you change the slide or? No, it seems that I got a message that we can now have a discussion.
Well, we have. Actually, I have a point, because we are looking at this new research that we have from
the perspective of the trust in our judiciary, and we have actually 52% of trust in our judiciary. That is maybe better than Italy and Croatia. And you can maybe comment that?
Yes, well, I was trying to compare how situation looks like in Latin America in general, and 2 years ago I was in some of my lectures comparing European data to Latino data. It also shows very interesting diversity. For us, for instance, from European perspective, all Latin American countries are the same. There is no difference between Chile and Bolivia. However, when you take a look into concrete data, it shows that effectively the situation on the ground is very different. And I think this is where we need to point our comparative efforts. This can be revealing. And again, well, while we are recovering the computer, I will try to push some provocative thoughts here. And one of the topics that I very much like to criticize is this discussion about procedural culture. Indeed, procedural culture exists, but it is overrated. I think that efficient judicial system is not a matter of procedural culture, it's a matter of procedural civilization. Once you achieve this fair and efficient system, you can speak about procedural culture, but you cannot cover the inefficiency by pointing to procedural culture, like many people in Southern Europe usually do.
I think we have a point.
I think we have a point there, and we need to just to stress that point because it's very important for us. We are changing our culture by our legislation. We have now a new code that actually has principles, starts with principles, and works a lot with cooperation, precedents, and the effort to have settlements. This is not the culture behind our legal tradition in the doctrinal way. Maybe we have to discuss a little bit more that because we are very influenced by Italy. And then maybe in the view of Italian scholars, we don't have, it's not possible to have this change. So maybe it will be interesting to hear about you. What is the role of the legislation in the change of culture? If it's possible to say that we need to adopt an approach more realistic and then work more with this new legislation in a way that we can be more in focus in the results of the judiciary and then work in that results to in a way more data driven, we can say.
I would say a few words on influence of Italian procedural scholarship in Brazil. I think that effectively it is a paradox because evaluated by contemporary standards, Brazilian judiciary functions rather better than Italian ones. So to have a role model that underperforms, it can only resemble the grandchildren who are still proud of their grandfathers, although they were basically much below their own level of achievement. Indeed, well, I must say that I love Italy, and it's a procedural scholarship when it comes especially to people. People in Italy are fantastic, just like people in Brazil, and we have many friends in Italy. I have delivered a number of lectures in Italy. Situation in Italy is also very diverse. Northern Italy has a different situation than Southern Italy. However, Italy has some deadlocks. For instance, it has some social issues, also legislative issues that they cannot overcome. Everybody knows that constitutional provision which allows access to the Corte di Cassazione in Italy to everyone is simply hilarious. It blocks the functioning of the Corte di Cassazione, and what happens effectively is that although everybody knows that, it is impossible to change the constitution because in Italy you just cannot have a social consensus that is strong enough to change the constitution. In procedural legislation, situation is somewhat different, and Italy has undertaken a number of different reforms. Some of them have started to produce some results, but again, the problem is where have they started to produce results? In Torino, phenomenal. Strasbourg project, no people behind that project, it works. Go to Sicily. Rather not be there. So, okay, are we there? Now we can, after this little potpourri of questions, now we can go further to the European rules of civil procedure. And again, repetitio est mater studiorum, let's start with the predecessor. And the predecessor here is the ALI UNIDROIT principles of transnational civil procedure. You know already enough about it, so let me just highlight some similarities and some differences between the global project on one side and the European project on the other side. So first of all, similarities. There are similarities in the function of the two projects. The function was to create the set of procedures that would transcend national rules and yet be able to serve as the basis for future initiatives in the reforms of civil procedure. There is another similarity, and this is the duration of the project. The project, the first one, the predecessor project, was going on between 1997 and 2006, so almost 10 years, and it seems that we are now in almost 10 years of the ELI UNIDROIT project. But there are also some differences. So first of all, obviously, American Law Institute and UNIDROIT produce the global rules, transnational rules, which should be applicable worldwide. However, interestingly, there was a much lesser number of people who participated in the ALI UNIDROIT projects. Basically, it was 2 to 4. It is now known as a Hazard Tarufa project, and sometimes you also mention Sturner and Gili, and that this is it. The others practically haven't left any noticeable mark in that project. And here, in this project, we heard from Sandra, there were over 40 people participating, or 40 professors from different places. And also, well, the nature of institutions that were participating in the project is somewhat different. Of course, UNIDROIT is the constant, and this is now an old body. UNIDROIT has been established as the International Institute for the Unification of Private Law in 1923 with the purpose to study needs and methods for modernizing, harmonizing, and coordinating private and, in particular, commercial law. However, American Law Institute is an equally old institution. Oh, better to say, UNIDROIT has celebrated 90 years just now, and American Law Institute was formed in 1923, so it is also an institution of a considerable age, so pre-war institution. European Law Institute, on the other hand side, is a fairly new institution. European Law Institute was formed in 2011, and therefore this is one of its first remarkable projects. It is a young institution, maybe this is why it is a vigorous institution, and it's also why actually European Law Institute was leading the project of the European rules, whereas UNIDROIT was just supplying, so to say, some background support, which we can also see from several indicia. One of them is, for instance, also a new thing, is that unlike ALI UNIDROIT, which didn't ever have a website, this project was publicized on both websites, on the website of the European Law Institute. Here you can see just one of several information from that website. And also at the same time it was publicized at the web pages of the UNIDROIT. Yeah, well, what I wanted to show, it seems that this is the old presentation, is also the new website of the UNIDROIT, where you can see that UNIDROIT doesn't even quote the name of the project in an appropriate way. They speak about ELI transnational rules of civil procedure, whereas they are obviously European. So UNIDROIT, so-so, but yeah, but European Law Institute definitely is this body. And also different. Well, there were no big working groups during the ALI UNIDROIT project. Now we had 10 working groups, and they were formed in different waves. Every wave of groups, so the initial working groups were formed in 2014, and then 6 months to 1 year later, we had the intermediate working groups, and then later again, 6 months to 1 year later, we had final working groups, and then even some post groups. So while some groups started to work in 2014, the others were just starting to work when the project was due to be completed, because originally it was meant to be completed until 2019. I participated in 2 of these groups. In one group, which was in the initial group, some provisional protective measures, and also in the group on obligations. And probably you will better see how many people participated by the presentation of names of the working group reporters. And the working group reporters, as you can see, are always 2, although sometimes they were, due to outside reasons, retracted to only 1. Because, well, of course, the reporters needed to be the leaders of an international group, and every group had 6 to 10 members, more or less. Some groups had even more than that, and had to reflect European diversity. Also, the knowledge of official languages of the project, French and English, and this is why most of the groups had 1 French native speaker and 1 English native speaker, but there had to be the others from north and south, east and west. And, well, there were also some ongoing changes in the composition of some working groups, and especially their reporters. They sometimes reflected the differences of views, and sometimes they reflected the differences of characters. And every group was a little bit different, seemingly. The 2 groups in which I participated were very, very different. The working group, which was originally chaired by Gilles Uniberti and Neil Andrews, was very much reporter-oriented, and then when the reporters started to quarrel, and ultimately they resigned both, we got Sandra, and we started to work in a collaborative manner there. But in the obligation groups, well, Professor Van Rijn and myself, we started to be very cooperative from the very beginning, and it would be only logical since we started with the principle of loyal cooperation. But I will try to show you that we effectively follow this principle in our work as well. Anyway, we see that there were many people involved. However, we don't see it here. You can check it also on the website. There were others in the other groups, and I will show you who was participating in our working group. But just a few words about the timing, and this is the brief recap of the development of the project, this project timeline, also to have this, for you to have this privileged access to, let's say, the process, how it started and how it was going on. So it started in October 2013 by a meeting in Vienna, and all 3 of us were at that time in Vienna. And that was meant to be just a pilot meeting to see whether to go on with the project or not. But the project got the green light, and then in 2014, first 3 topics were selected, first 3 groups started to be formed, and the first meetings of the 3 working groups began in 2014. In 2015 and 16, there were always alternating meetings of the reporters and also members of respective working groups in either the seat of UNIDROIT in Rome or in the seat of ELI in Vienna. But the groups themselves had held their meetings as well. And moreover, there were several presentations about the project. I participated in one in Budapest. There was a general presentation at the ELI General Assembly in Ferrara. And several times project was presented at the European Law Academy in Trier. And so it was going on, and it seemed that, well, the time is plenty, but since some groups were formed rather late, some people are busy, some people are less busy, some people are committed, some people are not really so committed because they have other obligations, and motivations of participants was different. And, well, it seemed that we will not be able to complete the project within this timeline. Indeed, timeline was a little bit extended. Originally, as I said, it should have been 2019, but the UNIDROIT allowed the extension, however, only for 1 year. And I feel that, well, this project has to end in the moment when it actually should have really began with discussions and with assessment. However, again, this is maybe just a personal impression. Anyway, what I want to also outline is that, of course, the European rules of civil procedure, when and if they're going to be enacted, they will have no binding force. They're just a model. But sometimes non-binding sources have more impact than the binding sources. I will again get back to the experience which I had in the United Nations, working there as a delegate in the Ancestral Working Group on Arbitration and Conciliation, where effectively the model legislation developed was a basis for national laws of many countries. And I was myself in position to transfer the models, both when it comes to model law on arbitration and model law on mediation, into my own national legislation. One big advantage of model legislation is that it has some chance to be coherent. The mandatory international documents are always a result of a compromise. And this is why, for instance, the European procedural law is messy. One big messy group of provisions which are sectorial, fragmented, and sometimes, well, at least hardly legible for a student of law. Maybe very good for professors to have something to play with, but this is not good law. Model legislation has a chance to be coherent and to have some background ideas. And moreover, there's another reason why European rules do have some chance to get effective. And this is the attention that they have raised internationally from the very beginning. Is the list of observers which participated in the work of this project, which participated at the meeting. They were there from the very beginning in Vienna, but also at some later meetings. I have put a footnote here and say, well, it seems that they were more intensely participating in the very beginning of the project than later. Later the project started to be more, so to say, chamber-like when it came to discussions. And I hope this actually reflects the duration of the project and not the quality of the outcome, although there may be a little bit of both as a reason. And still there is attention, and of course you can see that European Parliament has taken up some elements of this project already as well. And now we come here to the concrete rules, and of course one thing we need to admit in the very beginning, many rules and we cannot speak about all of them. I would also say that although the idea behind European rules of civil procedure was to have a more elaborate set of rules that could be converted into national legislation, it still seems that the document that has been produced is not readily fit to be just cut and paste into the national legislation, and at the same time it is seemingly too lengthy. So we need to make sense of it by taking some, so to say, chapters, some elements, and see what is behind it. And therefore I will limit to the work of the group that I co-chaired with Remco, and let's see what that group looked like and how our work was proceeding in different meetings. This one is in Pavia, this one is in Dubrovnik. Well, together with Professor Van Rey, I was the reporter, and the members were Professor Emmanuel Jourdan, Bartosz Karolczyk, Walter Eckberger, Elżbieta Sylwestry, Jean Serraggi, and Magne Strandberg. So we have some people from the north, curious little city called Bergen. Yeah, well, Professor Strandberg, a good colleague of ours, and just accidentally someone we all know, was there. But we also have people from the south, like Professor Silvestri from Italy, and also from the east. Dr. Karolczyk is a practicing lawyer. He also has not only academic but also practical perspective here. Professor Rechberger used to be the dean of the law school in Vienna, when Vienna was the city which was hosting the IAPL Congress on the Procedural Law in the New Millennium, which also shows this connection between the past and the present, about which we heard from Professor Van Reyes yesterday, and of course Franz Klein and his ideas were prominent in our work as well. Now, again, what was our starting point? Our starting point was indeed the transnational principles, and Remco mentioned yesterday a number of principles in his presentation, but he left out the most important one, leaving that, of course, for me in this presentation. And this is the principle 11, which is entitled Obligations of the Parties and Lawyers. And I must say that throughout our work, we tried to be faithful to our mandate, and that was to expand and not to change the transnational principles. We were trying not to go too far from the ideas of the principles, only elaborating them in some more detailed in a logical manner. It seems that some working groups, some other working groups, and also some critics of our work in our working group, actually did not have the same approach. There was a lot of elements that were not contained in transnational principles. Sometimes they seemingly were even changed. And also the criticism that we sometimes received actually referred to the points that were already contained and accepted in transnational principles. Only the question is whether everybody did know that. For instance, here in Principle 11, what we have from the start, we have the obligation to act in good faith. The parties and their lawyers must conduct themselves in good faith. We also have the emphasis on the shared obligation to ensure fair and efficient process. We also have a reference, also in the very end, to the professional obligation of lawyers. And we also have in Principle 11 some specific parts which point to case management, but also to determination of facts and law. And also in point 4, we have the emphasis on the importance of sanctions. So from very beginning, we actually tried to follow this in the structure of our work, and also in the structure of our text. We also had our manifesto. It was a paper which was written by Professor Van Rey, again with a historical underpinning, but that is the paper on obligations of parties and lawyers, which was published in 2012 in the Festschrift for Peter Gotthold. And, well, that was also the reason why, in the end, we tried to divide our work into subgroups. Again, the specificity of our working groups, we tried to have a general part, and then a part which was devoted to case management, determination of facts, determination of law, and the promotion of consensual dispute resolution. And every member was participating in a subgroup, but we all discussed all together. Then the rules were also prepared in advance by members of the subgroups, and then Remco and I, mainly I was engaged in fine-tuning of the draft and streamlining it. Remco was the ideological part of this undertaking, but we were actually all the time in line when it comes to the work, and we didn't have any major disagreements in our working group. In the end, also the project contribution of our group was a set of rules which was also logically divided into chapters. First, the general part, duty of loyal cooperation. Second, case management part about planning and management of the procedure. and then a part that's related to facts and law and the use of ADR and promotion of consensual or autonomous dispute resolution. And we tried to be, let's say, modern, but not to be too modern and innovative. We tried to follow some sources that are prominent but still progressive. Inter alia, well, not only Council of Europe recommendation, but the law of the highest courts in Europe, and importantly also the ethical codes of legal professions, because speaking about obligation of lawyers and judges, you cannot disregard the ethical component. So, for instance, we took an insight and followed also some elements of the Code of Conduct of European Lawyers and also core principles of European legal profession. And some other projects, for instance, national law of various European states, but also Código Modelo Americano. And based on that, we proceeded with our work. Our work was rather intensive. This is just an insight into the stages of this work. We worked in 6 different countries, in various cities, back in Maastricht, Leuven, Bergen, and Paris, and tried to work in a systematical manner. Also, well, we finalized the text during the 6th meeting, but then after the 9th meeting, we were trying to fine-tune it and work also on the language versions, especially, well, one of the meetings was devoted to production of the French translation. And what we realized there is a very interesting thing. When you start to translate some rules from one language, which is not your native language, into another language, which is also not your native language, you discover that it's a rather challenging task. And that if you want to be faithful, you need to change the original text in a way which is language neutral, which would make it acceptable and equally, so to say, consequential in both languages, in English and in French language. So that was an interesting and sometimes, well, not just a language exercise, sometimes really exercise which is bringing some changes and novelties. And yeah, now I think I spoke enough about the logistics, so let's go to the principal ideas. And I think these are the most important elements: procedural principles, procedural obligations. What are the main ideas and what challenges we have to face in this process as well. And, well, it may again sound like a repetition because, although I don't know Portuguese, I know that Hermes in the very beginning already announced that there is a starting point, and it has to do with cooperation. But let's see where this starting point starts and originates. Generally speaking about procedural principles, our working group tried to elaborate an integrative approach. And by integrative approach, I mean the approach in which the usual conundrum, or usual mess of various procedural principles that go into different directions, so you can prove practically anything, has to be replaced by one single key directive principle, which would follow the best past and present traditions of civil procedure. So what we wanted in particular to overcome was the opposition or dichotomy of two mutually hostile models of civil procedure, which then correspond to two principles which we can observe as model opposites. The one is, of course, the adversarial process, and this is a model of process where we have active participants and a passive judge. The other, on the other side, is the inquisitorial process. In the inquisitorial process, what we have is an active judge and passive parties. I will not elaborate at length these models. They are, I believe, very well known to you. I will also not elaborate their examples. Instead, what I want to just outline is that this integrative approach was the finding and the conviction that the best historical models of civil procedure, as well as the best practices in contemporary civil procedure, should be based on a completely different view. This view is that we don't need to oppose parties and the judge, parties and the courts. And this is not the system of connected vessels, where you either have active parties and passive judge, or passive parties and active judge. The ideal model of civil procedure is like the ideal model of society, the model in which everyone is active. And we also have models in everybody is passive, and I can speak about my own procedural tradition, which was kind of inquisitorial, but in the end it led to a model where we have both passive judge and passive parties. We wanted to have something different, a model in which both elements in this collaborative undertaking would be active and would share a common responsibility for the goal being a just and effective process. So instead of the adversarial and inquisitorial principles, and well, what we can see as just the examples of these principles are Roman canonical civil procedure, socialist civil procedure, we tried to phrase another model, and that would be a model that transcends the adversarial and inquisitorial principles that have been casting the dark cloud of ineffectiveness over the systems that adhered to their fundamental values. And we proposed the single principle, which is then now contained in Rule 2 of the current draft of the ELI UNITROA rules. And it says, parties, their lawyers, and the court must cooperate to promote the fair, efficient, and speedy resolution of the dispute. So, just to make it rather clear, we have a provision that is destined to fulfill a purpose. And final purpose of the process is to have a process that is both fair and efficient one. The general obligation of all participants in that process, of all participants in civil procedure, is to loyally cooperate in order to achieve this common goal. Again, what common goal? To contribute to education that is at the same time just. And of course, we don't have a crystal ball to say, well, this is just or not just. We need to have a process of appropriate quality that will enjoy public trust and not be apparently unjust. Because that is definitely not what we wish. However, at the same time, it needs to be effective in timing. It needs to have appropriate duration. By the way, it doesn't mean a reasonable time. Reasonable time is actually the threshold, the limit that you shouldn't go beyond. It's already too late. Timing should be appropriate. And it should also be a process that is adequate in cost so that it achieves another ideal, and this is the ideal of access to justice for all. Who has this joint and shared responsibility? Who are the principal players? Parties. But parties in civil procedure have also been overrated. Effectively, the actors in civil procedure are the representatives of the parties. In particular, lawyers, which should have not only party obligation, but also independent professional obligation to contribute to this common goal. And finally, there is the obligation of judges as professionals. However, not only of judges, it is also an institutional obligation of the justice system, and justice system does not consist only of judges. They need to be supported also through adequate logistics and administration, but also the organizational background, which will enable them to fulfill their job. What is the content of this basic obligation? The content of this obligation can be either negative or positive. Phrased in a negative way, it is the obligation to refrain from the abuse of procedural rights. In the positive way, it is the obligation to act actively in good faith. I would say that this first negative element exists in many procedural codes, although it's not really in practice followed by procedural players, especially in some procedural traditions. This other is something that is more novel. Obligation to act actively also means to act actively in order to try to settle this dispute outside of court, without the court, to exchange information, and to be not only passively but actively collaborative. Now, the wish of our group was also to make clear that the principle of cooperation is at the center of the circle of fundamental procedural provisions, not just one among the others. It is, of course, less important how this principle is going to be called. We can call it either a core principle or basic principles, and call it the objective. In different procedural traditions, we have different names. But it's important to have one core, and this is cooperation. And this core should then be surrounded by instrumental principles or instrumental rules, and they should have a relationship to this basic procedural principle. The other should also only find their full meaning through a set of general procedural provisions and fundamental notions that would support the core principle. In short, it is important to have a structure of the initial part of the rules, that was our view, which will make clear that there is a hierarchy and interrelation of the basic procedural notions. And have we achieved that? We will see. We'll now go through the rules. In any case, our rule is the first substantive rule. It is rule 2 in the current project, but well, there may be some issues with that. Some of you may find in this the echo of various procedural traditions that were the topic of the speech of Professor Van Rey yesterday. In particular, for instance, it can remind you on the English reform by Lord Woolf. In English, we have the expression of this key procedural principle that may be known to you. It is the so-called overriding objective. Interestingly, well, in other common law countries, or in Hong Kong, they call it underlying target or something like that, just to distinguish, but have basically the same approach. Woolf's report explained this overriding objective in the introduction of procedural reforms that then led to the 97 CPR rules. And he said, common law procedures tend to be guided in their operation through the introduction of a purposive interpretative provisions. And, well, very good that you were listening carefully to Professor Van Rey, because it is hard to say that this is only common law approach and only English approach, as we have seen almost the same approach in the starting points of Austrian reforms that happened 100 years, well, literally 100 years before the reforms of Lord Woolf. In any case, it is true that such purposive approach is still not broadly accepted in European procedural practice. And well, one of the questions throughout our discussion was, why are we doing this? And I must say that the work on model procedural rules really needs to start with the question, why are we doing this? I'm not sure that everyone who participated in the project asked that question, because motivations were rather different. But for us, from the very beginning, we tried to see who is our best enemy? What do we like to achieve? What would we like to fight? Where our rules could achieve some tangible impact. And we always wanted to see what is the model opposite of the rules. And we find this model opposite in the law and practice of quite some European civil law jurisdictions. For instance, contrasted to the idea of the purposive approach, you have a teaching of procedure that is rooted in hyperformalism, that starts and ends with the fetishism of technicalities. We also have a certain irritation in some countries by the idea of purposive teleological provisions. Procedure needs to be clear, precise. Judges should have no opportunity whatsoever to depart from stringent rules of procedure. Again, something that we didn't think that is good, that needs to be effective. And also in this tradition, general declaration and standards in legislation, if they are inserted in legislation, they are in practice ignored. In my country, we used to have an expression, well, if you don't know what to do, use the Constitution. Nobody will object and it's not going to achieve anything. But it sounds well. Well, this is not something that we wanted to achieve. On the contrary, what we wanted to have is, and I emphasize this again, we wanted to have a hierarchy. We wanted to have a combination of principles. The system in which we would start with the procedural obligation that would be shared among all participants, the obligation of cooperation, and this would then be combined to the same content of the obligation. So cooperation is not a value in itself, it needs to have a certain purpose, and this purpose is again a pursuing of certain fundamental values. And what are the fundamental values? Maybe we can add more, but the fundamental values are fairness, efficiency, and speed. We have, for instance, not considered the element of fairness, the right to be heard, as a principle which is separate and distinct from the principle of cooperation, but as a value which needs to be secured through a common and structured effort of all procedural participants. Again, when we see the current text of the rules, this might be less than obvious. Further on, we also have distinguished two working methods which serve for promotion of the fundamental procedural obligation and the realization of the three fundamental procedural values. And these two working methods are proportionality and the obligation to attempt autonomous dispute resolution, abbreviated as settlement. The principle that wherever possible, the parties need to attempt to resolve their dispute without the court. Only where settlement is not possible, the procedures need to be proportionate to the importance and the nature of the dispute, and this is the precondition for the adequate distribution of time and resources, and consequently for effective dispute resolution, which results in decisions which are fair, efficient, and timely. And for these objectives to be reached, and for the concrete implementation of the working methods, we need appropriate tools. Such tools can, inter alia, be found in the way how a procedure is conducted, orality, writing, publicity of trials, use of languages, a principle of assistance to legally illiterate litigants, and so on. And, well, all of that, methods and tools, is something that is in modern procedural language known as case management. So, from this scheme, it is obvious that the principles contained in the first chapter of the consolidated draft have a different position and different purpose, and we would like to make this known. So if they are placed at the same level and not as an element in an order or in a hierarchy of principles, values, and methods, this may send a wrong message. We still believe that this type of reading can be also read into the current consolidated text, because we wanted to show what was our starting idea when the rules were drafted. And again, let's see what is the evolution from the traditional doctrine of civil procedure. Where are these elements of the fresh approach? Also the points which distinguishes this project from the old conservative procedural theory, which is still taught in many places, and yes, also in Brazil and Croatia, even in the Netherlands, some elements. Well, one traditional element of procedural doctrine was the idea that the parties are the masters of litigation. Wonderful, I would say demagogically powerful argument. Partes sunt Dominic lex. I guess we all know Latin, that we understand what this means. And, well, what is the consequence? If parties are the masters, they have no obligations whatsoever. And then our textbooks usually start with the saying, well, whatever parties do in litigation is the expression of their freedom. They are there of their free will, they will exit out of their free will, and if they fail to do something, it is not a failure of undertaking an obligation, because nobody is going to sanction them. They will only make their position in litigation worse. In German theory, you know this as a debate between Lasten and Pflichten. Pflichten are strictly taken obligations that can be sanctioned, and Lasten, or procedural burdens, are, so to say, the obligation to help yourself and the God will help you. So if you don't, well, too bad for you, but nobody can force you to work for your own benefit. Now, is this artificial dichotomy still productive, and should it still be existent? Should we take this dichotomy of proper and mere obligations, and whether it really matters? Our position was that we should put effectiveness in the first place before the linguistics, so that we need to put aside this debate between Lasten and Pflichten and speak about obligations and only see how these obligations could be effectively enforced. And by the way, we have not subscribed to the view that there are no procedural obligations in a strict sense. Even in our traditional procedural codes, the duty to refrain from procedural abuse is something that can be sanctioned. The fact that sometimes courts do not sanction it for different reasons is their problem. It's not a problem of theory. Second element, who are the proper subjects of procedural obligations? Is that parties? Is that lawyers? Are lawyers always the parties? Is there an independent obligation of lawyers? Well, our view was that there is a unity of obligations, both procedural obligations of the parties and also professional obligations that need to be connected to a specific position of legal profession, to lawyers as officers of the court. And therefore, although the traditional position is we speak about the parties and let the codes of conduct speak about lawyers, it seems that if you leave something that is too important to be left to lawyers alone, to codes of conduct, you are not achieving what you want to have in the first place. So professional obligations of lawyers need to be, in a way, also autonomous and need to be a part of procedural duties as well. Again, in practice, as we see in many places, when we speak about parties, we actually speak about professional interests of lawyers. Professional interests of lawyers can be disconnected from the procedural interests of the parties. And only if we unite them, we achieve what we wanted to have in the first place. To speak about judges or courts, again, a novel point in the approach is that you cannot disregard one or the other. You cannot regulate some things in the organizational provisions, forgetting that there is procedure, and on the other hand side, to draft procedural provisions as a functional element of civil procedure, and then disregard as something what is interesting for, I don't know, judicial administration people, the rules on how courts are organized and so on. So we need to combine procedural powers and administrative support, and this is something that should not be forgotten. And, well, procedural proportionality. This is something that is, I would say, still a very novel element for many jurisdictions. What does procedural proportionality mean? Traditional view is that the courts and the judges need to be focused only on the case at hand and secure individual justice in the individual dispute. No matter what impact will that have on all other cases that are going on in the system. In practice, it means that you are bound to spend years and years working on a case of insignificant value, and thereby, well, impede the resolution of really important legal matters. Therefore, well, modern approach of proportionality requires proportionality of procedure to the importance of the case and requires a kind of systemic thinking, even from judges in individual panels and individual courts. You need to take into account what your work on one case has as a result on the other cases, and you need to allocate resources, time, money, and also the efforts of the litigants that are proportionate to the importance of the dispute. Because unfortunately, what we experience all too well is that resources of the world are, in the contemporary world, limited. Now, again, what is our best enemy? I would also like to show you what is on the other side. And you can say whether you recognize it or whether it is a blast from the past. For instance, non-collaborative practices in civil procedure. In my country, we have a number of jokes about lawyers' fathers and lawyers' sons. And one of the jokes says that the lawyer's son comes to the lawyer father very excited and say, "Father, father, I managed to settle the case." And then father says, "You fool. We were litigating that for 20 years and that case was feeding your education." So this is a kind of ethics which says that prompt litigation is unprofessional. You need to extend it in order to give more work to legal professionals. Well, even if you don't admit it, there are systems that still have a lot of financial incentives for protection of proceedings. You can have a system in which you say, well, lawyers need to act diligently and be fast. But if you have the rules on costs in such a system which award submission of unnecessary materials, you will have, so to say, a split personality. A lawyer who would like to be either ethical or rich. And you know the answer, what's going to be. Well, at least for some. Tolerance for delaying tactics and search for truth. Something also very present in the non-cooperative model of civil procedure. Well, after all, judge has a family, and in family you usually have another lawyer. And you need to have understanding for the same principles, C number 1, 2, and 3. And therefore, why would you, even if you can, sanction the abuse of procedural rights? And finally, even if you want to sanction, the problem is whether it's going to support it by the higher courts, by your colleagues, whether the sanctions will really be effective, or you will start to litigate about the sanctions of procedural abuse, and thereby instead of shortening the process, you will again extend the duration of the process. So these are all elements that we wanted to see on the other side. The model, the collaborative model, which we created was different, and you can see elements on this side. And let us now see the rules. The rules are, of course, on your computers, in your papers, and you can read them thoroughly. What I just wanted to show is what was our original idea and what is then in the current draft, so that you can recognize what was the idea, even if you read the current consolidated draft. So, first, the structure. Our rules were structured, as I said, in a way that was always pointing to obligations. Obligations here, starting with obligations of the parties. Rule 1, Rule 2, obligation of the lawyers. Rule 3, obligation of the court. And then Rule 4, sanctions. You may say it's a German approach to be very, so to say, symmetrical, but we regarded that it's important to be clear in the first place. Now, what do we have now in the consolidated text? We have everything, and at the same time, well, the question is whether we have everything. Can we see our ideas? I'll ask you. I would say yes and no. Well, what are the problematic elements? As I said, what we wanted to see is a principle of cooperation as a central principle, and then instrumental principles that follow. Maybe through the commentary, you can see that this is the idea, but you don't really see it in the text, because after principle 2, you have principle 3 and principle 4. So the question is whether you see this, well, connection of principles. By the way, in English CPR, the overriding objective is Article 1. And you can see clearly that this is the basis and the fundamental of everything else. Now, also, well, our work was about the obligation of the parties. Somehow it seems that lawyers and judges do not want to speak about their obligations. And therefore, well, it was softened by using the expression role of the parties and their lawyers. Like, well, you have a role, maybe your role gives you obligation, maybe not. So I'd say, again, you see a little bit of returning to this Lasten und Pflichten type of thinking. And, well, the text actually is not so different. We have these elements, but the question is whether it is clear or not. And in the discussion within our group, how was the final text faithful to our intentions? One word popped up all the time. We said, oh yeah, but it is diluted. You know what is dilution? Well, you have wine and you have water, and when you add water into wine, then the wine is diluted. And you can say that's fine. Well, in ancient Greece, you had the expression in ancient Greek, memegmata. Do you know what that means? Memegmata. It means never unmixed. Because, of course, for the old Greeks, it was dangerous to drink pure wine. So they had to always mix wine with water, especially when they were on their sailing ships, because otherwise the nymphs would actually call them onto the rocks, and the ship would become a shipwreck. But today, sometimes people think that drinking wine pure is better. We thought that pure wine is better, and that dilution is not necessarily a good element. One example, well, promotion of consensual dispute settlement is one of the fundamental elements of the principle of loyal cooperation, because this principle requires, first of all, not to use the resources of the court system unless this is ultimately necessary. However, what we have now in consolidated text is a separate principle of settlement. Again, to speak about principle of settlement is somewhat clumsy. We spoke about the obligation to attempt autonomous dispute resolution, which may be too many words, but if you just say principle of settlement, I don't know whether an average lawyer will instantly recognize what is taught by that. So we have here only in Rule 9, the settlement, again, not speaking about the obligation, but the role of the parties and the role of the court. So the relationship with cooperation obligation may not be entirely clear in this consolidated draft of the text. And, well, I don't know whether I have time to go through the specific part. This was the general part, but I have here slides which then show the special part, also comparing the elements of one and the other. And this is now the question for you.
We can a little more 10 minutes. You have
10 minutes? Okay.
I asked it for the colleagues and it said you were free to go until 11:30.
The colleague said I was too long already.
The colleagues said that they are.
They say they are right. Yeah. But okay, let me try to be quick. Well, I'm only going to outline few elements, and well, we'll see where we go from there. So we had this general obligation, general procedural obligation, and then we had rules on case management, determination of go here, determination of facts and evidence, determination of law, and attempts to reach settlement. And well, let's now see what were the issues that were debated in our working group, what we decided, and this is again something that shows well, this process of development and the possible controversies that we were faced with. So let us start with the issue of shared responsibility and cooperation in all specific fields. We have seen already that there is a general duty of procedural obligation. But should this general duty be different when it comes to facts, when it comes to law, when it comes to case management, when it comes to settlement? Our idea was that this cooperation obligation exists in all respects. So, for instance, well, customary approach, da mihi factum davot ibi jus. It is a statement which says, well, the parties need to be active when it comes to facts, and the court needs to know the law. Jura novit curia. Should this be so in the modern key? Well, indeed, there should be a kind of division of labor, but should parties be completely dispensed from pleading the law on one hand side, or should the court be only totally limited by the submissions, factual submissions of the parties? The idea of loyal cooperation says there should be joint and shared obligation in all respects. And we will go on through the rules. I will show you where and how. Well, the question of terminology was also discussed, and just quickly, well, we thought that although lawyers usually like to have a very precise language, we thought that here functional approach is better. Sandra told already that functional approach is something that we should all attempt, and not just to be captured by words. So, for instance, to speak about sanctions or consequences, well, we can have a whole seminar, spend 1 year, whether that would matter or not necessarily. Also, the question of proper placement of rules. That was very important also in our dialogue with the steering committee and with the other groups. Shall we be conventionally captured into the division of legislation and say, well, civil procedural rules are only functional, then you have the rules on courts, you have the rules on other players, that is the organization part, then you have the rules on professional obligations, and then you have a separate laws on ADR. Well, probably every national tradition has specificities, and you need to put one rules here, the other rules there, and then you have a coherent system. But for an international project, it is more important to have clear ideas. And therefore, we intentionally disregarded whether something is also important for the other type of legislation. If this is important for the idea, for the project, then it needs to be in the model, and then everybody can see where to put that. So some overlapping, of course, can, in such a situation, happen. Relationship with the other working groups. Of course, there was a working group on evidence, but we needed to discuss fundamental elements, not the technicalities of evidence. So we needed to have some rules on taking of evidence, on pleading facts, and so on. It is, above all, it has been important to preserve the teleological approach. And also, well, we received some criticisms at some of the meetings, and some members of the steering committee also stated, well, you know, the way how the rules are drafted is a little bit different. This is not so strict technical language that is the language of the rules of civil procedure. This is written in a different way, so we would need to consolidate it and make it more, so to say, strictly procedural. And well, this is probably a point which I would fight the most, because if you speak about model legislation, it is an illusion that you can write a model legislation that will be directly convertible into all national systems of a continent, not to speak about the world. What you need to convey is the meaning. And indeed, every model law is written in a more general way. And well, I would say that I have more experience in drafting global model legislation than most of the members of the steering committee, since I worked for 10 years in the United Nations. I worked also 5 or 6 years in drafting committees of the Council of Europe. So one can know how to phrase international legislation, international model legislation. However, that was not always accepted. We wanted, in our approach, to convey clear ideas and not mechanical solutions. Maybe it is a little bit different from some rules in this project, but I would say it is different in a good way. And now let us see the individual issues and then what the group wanted to achieve. Very briefly, case management. Again, let's start with model opposites. Systems without case management. Systems in which you have some formal supremacy of the court over the parties, but no effective tools, since everything in the end depends on the lawyer's initiative. And of course you can say that it's wonderful because it is a case of contractualization of civil litigation. Does it always contribute to good system, good administration of justice? I would say that, well, even in the model of contractualization, you need a third element, and this is the court. You need to take into account the interests of all litigants, not just concrete litigants in this case. In such a model, of course, you don't have the front-loading situation, the very early planning of the procedure. You don't have procedural calendars. You don't have a collaborative effort to agree on something that is acceptable both for the court and for the lawyers and for the parties, and to see and plan how things are going to go in the next several months or years. I had in my practice a number of international arbitrations where we had to plan procedure for 2 or 3 years in advance. In the beginning I thought, well, it's impossible. You cannot possibly anticipate how it's going to be. But I started to work with some efficient Swiss arbitrators, and later I also managed to plan, and in 90% of cases, calendar was followed until the very end. And if there were departures, well, probably 2 or 3 months here or there, but it was not a journey without a timetable. This is something that in litigation should also be the practice in courts. However, it's not always the case. And Professor André already spoke about interim or intermediate appeals, something that also needs to be limited. So what do we create? What did we create in our rules? We created rules on the management of the procedure, which were again speaking about the obligation, principal obligation to actively manage the proceedings of the general management duty. And then we have particular tools like case management conferences, the preparatory meetings, however you want to call them, as one of the good practices in civil procedure. We have case management orders, this way how the court, in cooperation with parties, regulates the courts of procedure. And then we have a list of different means. In the current consolidated text, we basically have most of that, probably because John Sarachi was the one who was drafting the rules on case management and was also active in the final consolidation group. But still, we can see whether the placement of case management rules is prominent enough, because we have in the very beginning the rules on obligations of the parties and so on, and the case management comes only at Rule 47, and language has been a little bit changed. We never discussed the expressions like careful conduct of litigation, but it must be, well, this wealth of English language that only English native speakers can produce. Isn't that so? Well, also some phrases were a little bit shrunk, like, for instance, if the parties agree on a case management measure, the court shall not determine differently without good reason. And I would, again, dare to say that our original rule was more precise and more concrete than the one that is now here. But more or less, rules on case management are here, and this is definitely going to help for some legal systems. The rules on determination of facts. I will be very brief here because there are not many discrepancies. Again, what we wanted to fight were non-collaborative practices in determination of fact. No right of the court to enter into fact-finding, also poor collaboration in timing and submission of evidence. Well, one element which we shared with the other group was that yet another famous Latin expression, which is prominent in many systems, nemo contra se edere debitor, not valid anymore. You need to, in a collaborative model, you need to have an obligation even to supply information that is adverse to your interest. You're not going to self-incriminate yourself. We're not speaking about criminal proceedings. Maybe, well, even in criminal proceedings, sometimes you may have this, at least in the smaller cases, a stronger obligation. So these were the best enemies, and on the other side, the rules that were produced were, again, obligation to present facts and evidence, a right to disregard belated facts and evidence, consequences of a failure to introduce facts and evidence, closing of the proceedings. These rules were generally taken into consideration, and now you can find them in the chapter on the management of evidence. And, well, I promised to be short, so I will not enter into details. Only one element, probably, whether with so many rules we again have a clarity of the obligations. Because one principal issue that we needed to see and discuss is whether the court can take evidence ex officio. And this is basically this place where you can see that this is a shared obligation also when it comes to facts. It's not just that the parties supply the facts. Sometimes the court can and must find facts ex officio, and for that purpose it needs also to take evidence ex officio. In our text, the text of the obligation group, it was present in the Rule 13, the court shall ordinarily consider only facts and evidence introduced by the parties. However, it may consider facts that appear from the case file or take evidence on its own motion if it deems that under the circumstances it is necessary to the proper adjudication of the case. And this is, of course, a fundamental rule, and this rule hasn't survived in the consolidated text because, in the end, what we have is a very brief reference in paragraph 3, which says, exceptionally, the court may order the taking of evidence. So everything what has been stated there is now being crammed into one word, and this is exceptionally. Maybe it's a better word, we can discuss about that, but we didn't have an opportunity to actually discuss about that with the steering committee, with the others. It has simply been now drafted in this last moment in this way. Where we have more objections is, and probably the most principal objection to the outcome, is the determination of law. Here, Professor Jolin was the one who drafted that, and we discussed it also very thoroughly. Again, our idea was to have a collaborative model, the model in which you wouldn't have this separation of obligations where parties provide facts, and no matter whether parties have the most expensive lawyers who earn 5 times more money than the judges who have to decide, these lawyers need not supply anything in terms of legal arguments, because the judge needs to know the law. So you just unload your case to the judge, and then, well, see what to do with these facts. Anyway, this was something that we had clearly in our proposal. The Rule 20, if a party is represented by a lawyer, the court may impose sanctions for failure to plead law or respond to legal allegations to the other party. So the idea was that, of course, if you have unrepresented parties, if you have litigants in person, not every country has such a generous system of legal aid like Brazil, where you would always get a public defender. In many countries, litigants are there alone, and then the judge needs to intervene and needs to know the law ex officio. But when you have represented parties by lawyers, it should only be natural. It, by the way, something that the practice of international courts also knows. You cannot just state the facts and then ask the European Court of Human Rights to find what type of violation that is. You need to provide also legal arguments. So definitely this was the important element of our project. In the end, we actually lost that, thanks to Professor Stürner, I think, but I'm not quite sure, because Professor Stürner at one of the meetings stated, no, Juranovic Curia is too strong, too accepted, we don't have this opportunity to impose professional obligation to plead the law. So what we got in the very end, we have, well, provision on applicable law. The parties, not anymore must, the parties may present legal arguments supporting their claim or defense. And, well, interesting, probably because the authors of the consolidated draft forgot it. We still have Rule 22, where it is stated that the parties must bring all the legal and factual elements in support of their claims. So we have a apparent contradiction of some of the rules in the draft. Anyway, I'm not going to enter into the other elements. There are some other elements, whether, for instance, well, we had a clear prohibition of surprise judgments. We had this as an element in our draft. It's still here, but a little bit covered. And, well, finally, as I already said, settlement, obligation to attempt settlement is very important for the collaborative model. We have a number of non-collaborative practices, and therefore we had a whole chapter on settlement and ADR. But again, it was a decision to leave the ADR. That was a kind of political wish of the Unidroit, leave the ADR to the others, reduce this to a bare minimum. Unfortunately, we have preserved the bare minimum, so there are some rules. These rules are now in the consolidated text in Rule 9. But of course, we can ask whether we have this coherent draft now, because on one hand side, we have very extensive rule on collective settlements. The whole chapter here, settlement in commenced collective proceedings. And we have something very conservative, a rule on judicial settlement, something that old German scholarship would be proud of. But any modern element here has been actually removed or just left to the bare element where, again, we don't have obligations, but the role of the party and their lawyers. Again, I will not, I will wrap up here. I will not enter further into any dialogue with the current consolidated draft. Maybe I create a wrong impression by criticizing it. I still think it's a very important text, but just as every text, when many people participate for different reasons, you have the, so to say, fight of authorities and the fight of motivations. And in the end, well, had we been able to discuss for 10 more years, maybe we would have come to a better end result. But still, well, main things are here, what we wanted to have, why cooperation as a principle matters. Here is just a wrap-up, which I usually present. Well, we need to have a clear text. We need to give guidance, the practice of the procedure. The clarity and the teleological approach is important, because if you have a clear principles, then you have a clear guidance in interpretation of technical rules. You don't have just, so to say, well, headless technical rules. You know, the story about presentations and presentation without PowerPoint is both pointless and powerless. So here also you need a clear guidance, you need a visual guidance. So we wanted to emphasize use of cooperation as a joint and shared responsibility. Also is something that is not only an element of procedure, it's an element of procedural ethics. Just like Franz Klein in Pro Futuro said, well, it is a kind of ethical obligation to contribute to the society. It is not just your matter to fight in front of courts which are a public facility. It's something that has effect on everyone. So here also, this applies in particular to lawyers and judges. It's something that needs to be interiorized. It's often just paid a lip service, so that lawyers are officers of the court and that the judges need to adjudicate effectively. This really needs to be an element of professional ethics, also professional education. Case management, again, something that is not known in many parts of the world still. I was last August in Chile. I see that in Latin America has discovered case management. We had a wonderful conference there where we discussed about the notion of case management, but in many countries in Europe, case management is not really embraced. We also wanted to introduce the elements of proportionality in the relativization of the rigid division of labor between the court and the parties in these elements, and importance of autonomous dispute resolution, because, well, if you want to have strong and active citizens, they need to take their own disputes in their own hands. One of my friends, who is a judge of a senior court, but also the president of the Croatian Mediation Association, usually starts his speeches by saying the dispute is too important to be left to the courts. You need to take dispute in your own hands. And, well, this type of, well, bringing the parties out of their self-imposed adolescence. Just to quote Immanuel Kant, who was speaking about enlightenment as the exit out of the adolescence and taking maturely things in their own hand. This is something that we wanted to achieve in respect of settlement. So thank you very much for your attention. Sorry for being so long, and the discussion is still here. Thank you.
Thank you, Professor Alan, for this very, very powerful lecture. I think that we were all discussing this matter for a long time here. And as we can see, we have a great connection with your ideas in the working group and what we have in our civil procedure now with the new code. So we use these tools that you and Sandra and Branko gave to us to improve our comprehension of our real and present reality. I think now I can address just 2 words in Portuguese that I think they are important for the audience. Nós não tivemos tempo de debater entre nós. Então, tomei uma decisão aqui, junto com a professora Trícia, nossa professora também do programa de pós-graduação, professora da universidade, e nós vamos fazer uma nova sessão em março, depois que nós tivermos os vídeos editados e disponíveis para todos, para que nós façamos uma discussão sobre essas ideias. Tá? Acabei de ter a ideia de talvez fazer uma web conference, talvez com os professores, para complementar, caso eles tenham disponibilidade. Mas, de qualquer forma, nós faríamos a nossa, como dizem em italiano, seduta. É uma oportunidade de estarmos sentados discutindo esse tema em profundidade, fazendo nossas considerações e as nossas observações para que nós possamos avançar. Eu não vou retomar agora, justamente em razão disso, as ideias colocadas pelo professor Alan, porque eu vou passar diretamente a palavra ao professor Halvard Friedrichsen, que é da Universidade de Bergen, e agora está conosco aqui no Espírito Santo durante algum tempo. Se ele aceitar o meu gentil convite, que tenho feito várias vezes, ele irá de alguma forma integrar o nosso corpo docente aqui de trabalho, mesmo que informalmente, nós precisamos conversar sobre isso depois, e nos auxiliará a compreender ainda mais essas mudanças que estão acontecendo na Europa. Eu não vou recuperar tudo. Eu só queria estressar 2 pontos importantes. Primeiro era esse da conexão direta com o que nós já temos na nossa legislação, o quanto nós estamos avançados. E o segundo ponto muito importante é a quem nós devemos prestar atenção. Nós devemos prestar atenção em modelos que têm uma menor confiança no sistema de justiça e uma menor eficiência, ou nós devemos prestar atenção nos modelos que têm sido bem-sucedidos e que a confiança da população no sistema de justiça tem aumentado. Então, eu vou deixar vocês com essa pergunta, para que vocês reflitam, para que vocês estudem o material que foi disponibilizado, e I'm switching off to English, and switching to English again. Professor Halvard Friedrichsen from University of Bergen, it's our pleasure to have you here, and now we will have the floor.
Okay, thank you. I will try to be brief towards the end, but many thanks to Alan Usland for this very broad presentation of the ongoing harmonization of civil procedural law in Europe, and of course the ELI UNIDROIT project in particular. And I have to say I particularly appreciated the insights we got into the internal debates and tensions within the project. The different approaches of the various working groups and the changes made in the consolidated text at the very end. I think that's really interesting. I will come back to that briefly. But first, also many thanks to Professor Elmer Zanetti for including me in this exclusive company. You should all know it's really quite a trio of experts he's been able to get to travel all the way from Europe. And then he matched it by distinguished Brazilian colleagues. So this is, if I could have a dream team like this in Bergen one day, I would be very happy. So it's really an achievement. Looking at the program though for the summer school, I have to admit at first I wondered, what's the relevance for all of this to Brazil? But then I realized, however, that Brazil, much like my own country, seems to be very open to ideas from the outside. This is not about uncritical adoption of Italian or German thinking. It is about adopting the suggestions that may improve your own system and politely putting the other ones to the side and learning from others' mistakes. I think this is a very sound approach, and I think it should be followed also with regard to the ELI Unidrive project. And that brings me to my first question to Alan. Will you somehow make public the original drafts and papers from the working groups? Because some of us already have them. These are not state secrets, but they are not public. So it would be really useful for us to have them, to be able to cite them, criticize them, discuss them. And for outsiders, like in Brazil or in my own country, if we consider Alan's original proposal better than the consolidated text, well, then we are completely free to opt for the original proposal. So this is just not for academics. This could have a real impact. It would be, perhaps it would be controversial within the ALI Unidrive project, I don't know, but for outsiders it would be very much appreciated. My very small contribution towards the end is just perspective of a European non-member of the European Union. Europe is important to stress in these Brexit times. Europe is much more than the EU. There are 48 member states of the Council of Europe. There are now only 27 member states of the European Union, and these include, I would say, quite important countries like Switzerland, the UK, of course. Norway is not a big country, but still the economy is quite significant. So remember that the Europe is more than the European Union. As far as the ELI Unidrive project is concerned, that doesn't really matter, because non-EU representatives from non-EU member states are also included. That's very much appreciated. So in academia, there is no hard Brexit. There is only soft Brexit. And that's very good. But when it comes to the later follow-up of this, the ongoing harmonization of civil procedure in Europe, this EU, non-EU divide may matter quite a lot. It is simply not possible for the EU Parliament to force non-member countries to adopt new EU procedural rules. So, and this is important, any novel EU rules in this field, they need to be so good that we on the outside adopt them voluntarily. And to some, I would add, to some, the fact that rules, future rules in this field stem from the EU would be a problem in itself. It shouldn't be for academics. So the quality will not only be about quality, the fact that new initiatives will come from the EU will be considered a problem, and we all know what country I'm thinking about in particular, across the channel in the UK. And therefore, I was probably the only one in the room, but as an outsider to the European Union, I immediately react with a smile when Alan had a little slip of his tongue talking about the EU Parliament as the representative body of European citizens. And it's not for us on the outside. But I'll just be brief. I just have two questions. The one is concerning trust in the judiciary. Very interesting. Very interesting. I noticed that I must pick it up too. And you didn't include the non-EU countries in your slide, but Switzerland, Norway also scores very, very high on these surveys. There are a number of reasons for that. I will be very brief. Very low level of corruption, of course, important. There's generally good quality of the judges, which means they are well paid, because a good civil justice system costs money. You have to pay judges well to attract the right people and make sure that they are not that they can focus exclusively on their work. Then the courts in Scandinavia are usually quite efficient, and the appointment procedures are completely depoliticized, which is also important. and these are always the reasons that Norwegian, Danish, and Swedish judges come up with when we ask them about the trust in the judiciary, and they are very, very proud of this. So we'll add some other reasons that is not due to the judges, but more the system. One of this is that in Scandinavia, all citizens have a high level of trust in public institutions, not only the courts, but the state in general. Second, which I think is quite important, is the fact that we have very well-functioning legislative bodies. So difficult, really hard political questions are decided by Parliament and not left to the courts. Because if it's up to the court to decide whether gay marriage is okay or not, or whether you should allow abortion or not, then of course a lot of citizens will disagree with court decision, whatever way it goes, and the trust in the courts will go down towards at least 50%. But in Scandinavian countries, these political questions are kept out of the courts and decided in Parliament. I would just add that even though I sort of pride myself, or at least Norwegian judges do, that we score so well in these surveys, I'm a bit skeptical to these surveys, because I don't think judges should be guided by the desire for good approval ratings, and particularly not when part of the job is to defend the law also in unpopular cases, defending minority rights and so on. A judge defending minority rights will not be popular. His approval rating may go down, but it's still the right thing to do. So I'm a bit skeptical, because when you ask people about trust in the judiciary, what are they really answering? That they disagree with certain decisions, or that they in general trust the civil justice system. So that was just, and coming back to one of Alan's points towards the end, will parties be happy with very effective case management? Well, perhaps not. Because if you think your case is really important, and the judge thinks this is not important, then we have this is half-day hearing and strict case management, and this is the resources we have to spend on that time. In this case, the party may be very unhappy, lose faith in the judicial system, because he thought or she thought the case was much more important and deserved a 3-week-long hearing. And still, it's the right thing to do. But effective case management could decrease trust in a way. It depends how you phrase your questions. So, and that leads me to my second question to Alan. When you see the difference in trust in the different European EU or European states, could it be argued that a certain trust in the judiciary and judges is a prerequisite for harmonization of procedural law? Or perhaps not trust, but at least a common level of distrust. Because in the Scandinavian system, our civil procedural law are based on a lot of trust in judges. And if you trust the judges, you can leave them a lot of discretion. You can give them a lot of powers, case management, cooperation. You can leave a lot of power in the hands of the judges. And it works. But would that work in a system where you don't have that level of trust in the judges? So you could say, it's a question about the horse and the carriage, but if you harmonize procedural law and trust in the judiciary is so different, will it work? Because when we write our civil procedure code, sort of the starting point is this is the level of trust, and for that reason we can regulate as follows, if I make my point clear. And just a very brief final question, the last slides concerning duty to cooperate and so on. My question is, of course, concerning the sanctions, because that's the proof of the pudding. Without effective sanctions, this will not work. We have in Denmark, Sweden, and Norway, there's an explicit duty to cooperate. There is an obligation to disclose all relevant evidence and information, even if it doesn't serve your interest. But we don't do that. The lawyers don't do that. And there will be many parties out there not interested in a lawyer who is cooperating, if they know their case is not a good one. So unless there are efficient sanctions there, you could create a system where the lawyers not playing according to the rules will be the one winning in the end. So sanctions, that will be my final question. But great many thanks.
Thank you.
I will ask Alan to pass the floor to Tricia, and then we can close with your answers.
Good morning to everyone. It's a great pleasure to be here. I want to thank Ernest for inviting me for this summer course. It's a great opportunity for our students to be here and to learn a little bit about European rules and transnational or whatever rules. And it's a pleasure to have you here, to have all the professors here. And I'll be very fast in my questions. We have a lot of judges here, and I want to know how many judges were in this project, working this project, how many lawyers you have listened to this project, especially for this case management. It's my first question. And on a specific question about settlement and agreed proceedings, we have this rule on Article 57 about the agreed proceedings, and I want to know if it's implicitly included on the settlement principle that it's on Rule 9, I think. So that's my two questions, and I want to thank again Hermes and everybody for your attention. Thank you.
Very good. Now, Alan.
Yes, well, all very interesting questions and comments, and let me see, 13 minutes would be too little to respond to all of them. So just very, fragmentary remarks, but maybe also to make you think about further questions that we can elaborate during coffee break or lunch. So, first question, whether we intend to make our rules public. By the way, not only that we intend to make our rules public, I am aware of several publishing projects of different groups that will probably publish books about their own work. So definitely there will be spin-off procedural literature, and this may be a good thing and may also contribute to discussions. However, question is how influential is this going to be? Actually, already in 2018, in Dubrovnik, the Public and Private Justice course, we organized a discussion about the European Rules Project with a view to publish, so to say, let's say a little bit different publication about the European rules and the whole project to start the critical examination of the rules, and also to present some perspective which will be different. But then it turned out that well, the project will not be finished in 2019, and now we don't know when it's going to be finished. I've shared also the fear that it might somehow face trouble in the very end, especially because, well, it obviously left some hard feelings with, well, even the members of the structure group, who, by the way, still are on the internet as rapporteurs, Kadie and Kramer, and well, seemingly the other two members have been more active in the last part of the project and not the reporters, which is, of course, for procedural, it's something that is completely unimaginable. It's like having janitors of the court decide cases instead of presidents of the panels in the court. But anyway, this is just my reflection on that. So yes, we are going to attempt to make a publication project. It's less ideal than having a sort of say a good text adopted by international institutions. There will obviously be a little bit of so to say window dressing in this process. Many people participated, so now you have a question. Either you're going to show yourself as a part of the success and then take a little bit of the fame and suppress your critical remarks, or you're going to be outcast from prominent institutions, or not being invited to Luxembourg ever again if you say something against the rules on list pendants. So maybe we'll see how this is going to to work out. My idea is to be more open and to, well, actually I have to admit some things and take the blame from the very beginning. ELI has had a kind of a secretive policy with the drafts, so we were not allowed to distribute our drafts up to a certain point, and only after I provoked this question at the last meeting, asking whether we may distribute these rules, there was a kind of a low voice expressed answer by Diana Wallace, the president of Forbes. Yeah, there is no objection to that. But of course, I have distributed the rules among a number of colleagues. I have spoken about them. I don't think that such things should be prohibited. So if ELI wants to sue me, I'm here, and I will try to defend the transparent position in this respect. But so much about publication. Well, approval ratings and whether judges need to act in order to satisfy the approval ratings. Again, interesting point, but I think that this is yet another myth, or well, I would say overemphasized element in judicial debates. I often meet statements from members of the judiciary, especially in my country, which has very low ratings, and they say, this is just public perception. In fact, we are beautiful, we are wonderful, and we can show that we are independent by this hostility of everybody against us, because we work no matter what. Well, I don't buy this. Although my general position towards humankind is rather skeptical, I must say that this is one of the right surprises which I always had when I compared the public indices of trust with the tangible, let's say, not perception-related data about the functioning of a particular justice system. Of course, there is a little bit of a general situation, and it's very interesting to compare the general trust in institutions and see where judiciary is as a subsystem. In some countries, when you have a political crisis, people don't believe to anyone. However, you do go into details and you will see exactly how things look like. Maybe you would have to adjust, but in the end, to my greatest surprise, here democracy is right. Perception usually does correspond to reality. And I would here critically examine your second objection, saying, yeah, well, parties are certainly not very happy if they have effective case management, which allocates more resources to more important cases and less resources to less important cases. This is also not something that lawyers would do. Again, I say this is a matter of bad legal education. This is something that we tell to our students, actually trying to provoke unethical action from them. I've been in contact with many people and many litigants, and I know, of course, there are always some people who think that their case is the most important case of all cases in the world, no matter which one. But how many are there? In every court system you have, we call them the patients. Those who don't find any other sense in life but to go to the court and burden the court system. And of course, they will be these 1% in Denmark who are not happy with the independence of the courts. But the rest will generally be satisfied, even if they lose the case. Oh, I have a lawyer in the family. My wife has a law firm. And, well, I always try to see, and I'm always cheating, trying to provoke her and cheat her into telling that she will do something unethical. She very rarely does. Actually, she likes that, but she doesn't, overcharge. She says that, well, being moderate and yet
appropriate, is the best business policy, she's been survival like that, and a number of others. So therefore, I don't think that we have to take these popular myths. This is a hoax, in fact, you know what a hoax is. And we would need to go a little bit further and see how it looks. My belief here is that perceptions generally do correspond to reality. And now, about participation of judges in the project. We did have quite a number of judges in this project, although we have to admit the vast majority of participants were law professors of procedural law. But every group had at least one or two professionals. Our group had a lawyer, but I would say that some of our members had experience as part-time judges. I had experience as arbitrator in a number of cases. Well, John Sarabji is the principal counsel of the President of the Supreme Court of England and Wales, so he's supposed to know something about judicial realities. We had discussed this with judges at some conferences. For instance, Gabriele Sabatino was the Italian judge, was very positive about our proposals, and well, unfortunately, he's not Italian judge anymore. Now he is the judge of the European Court of Human Rights. Again, a judge, but he's been actually promoted, if I'm not mistaken, because I was taking a look at their website some time ago. It seems that he's now there. But there were even some judges of the European Court of Human Rights in the beginning as observers. And I think it's very good. Although, again, I would like to say something that would not conform to many ears. I think when it comes to drafting procedural legislation, the lead must be with the professors and not with judges. Judges are masters of the application of law, but not the masters of creation of law. And there should be certain division of labor. Some people have been trained to think systematically, although maybe they are not very good decision makers. And then we find them in law schools. Some people are trained to deal with cases, but of course to have them as principal drafters, at least in my country, it's usually disastrous, because then you often get, so to say, fragmentary perspectives as a law which is supposed to work for all. So more or less, this you asked me about Article 57, and
it's about agreed proceedings. If the idea of the proceedings is this included on the 7th rule, Rule
9. We haven't spoken a lot about agreed proceedings. I also noted that some ideas were later inserted, especially in the rule on applicable law, where, again, this idea that the parties can agree on only some parts of a dispute to be handled. Again, my view is that it's a nice innovation, something that could probably 1 in 1,000 cases result in something interesting. A wonderful topic for several dissertations and a couple of master theses, but not something that we have to put in the forefront. It's not going to be very broadly used in practice. It is probably, well, if you want to engage your efforts, disproportionate to put too much emphasis on that when you don't have settled this underlying philosophy that basically, well, what you need to achieve is a system of justice which is good for litigants, for their lawyers, for the court, but also for society as a whole.
Thank you, Professor Allen. And I will ask you all to a big hand of applause for our green team, as said by Howard, Professor Allen Zalach from Zagreb, Professor Branko Van from Maastricht, and Professor Ksenda Kramer from Rotterdam. This is not the end, but a new start, the beginning. So we'll keep in touch, and I will thank you all for this beautiful conference, and looking forward to see you again soon.
Vamos tirar uma foto com todo mundo que está aqui. Vamos pedir para eles tirarem uma foto nossa e aí vai encerrar.